Immediately after an accident, if you're injured, you should contact or have someone contact on your behalf 911 to make sure that an ambulance attends. If you don't require an ambulance and there's property damage of some significance or you're in pain, then you should contact the police. If the police do not come to the scene and instruct you to attend the collision reporting center, then in that case, you should take out your phone with a camera and exchange information with the other side and take photographs of their insurance information and driver's license. And I would also recommend taking photographs of the position of the vehicles and the property damage sustained to both vehicles. You should contact a personal injury attorney as soon as it's practical to do so. First and foremost, take care of your health and your injuries. Once that is under control or stabilized, then you should contact a personal injury lawyer as soon as possible. And there's several reasons for that. Number one, usually the insurance adjusters want to contact you to get a statement before you retain counsel to try to get information from you. It's important to have a lawyer to assist you with that and to assist you with the information that's provided to make sure you don't jeopardize your case. In addition, there are statutory requirements in terms of putting various parties on notice or timelines to apply for accident benefits, and some of those timelines are very short. So it's definitely in your best interest to contact a lawyer as soon as possible. In most cases, to file what's called a tort case, where you're suing the third-party vehicle, or in a slip and fall case where you're suing the at-fault party, typically you have 2 years. In terms of accident benefits cases, you are supposed to notify the insurer of the circumstances arising from the accident within 7 days, and you should apply for accident benefits within 30 days, although there are exceptions to that and exceptions which provide longer time limits under certain circumstances. In a personal injury case, it depends on the case. For example, if it's a motor vehicle accident, there's actually 2 cases. So there's an accident benefits claim where you can seek accident benefits for an income replacement benefit if you're unable to work, for example, or if you were never employed before the accident, you can claim what's called a non-earner benefit. You can also claim for treatment, and if you need someone to help look after you, such as a personal support worker or a nurse, that's covered as well. The second aspect of the case, which applies to not only motor vehicle accidents, but slip and fall cases and other types of injuries, that's the tort third-party case, and in that case, you can sue for your pain and suffering. You can sue for your loss of income, you can sue for your treatment, both past and future, as well as any other losses you have that relates to the accident. If the insurance company offers you a settlement and you do not have a lawyer, I strongly recommend that you do consult with a lawyer to go over the offer to make sure that it's a fair offer and reasonable. Often the insurance companies will provide very low-ball offers when you don't have counsel early on. And once you accept that offer and sign a release, you can't go back and get more money. If an offer is made while you have a lawyer, the lawyer will go over the offer with you. You should ensure that your lawyer explains it to you carefully and you address all of your concerns. If the at-fault party's insurance company contacts you, I would recommend not speaking with them at all. You have no obligation to do so, and at that point you should consult with a lawyer. As far as my practice and my recommendations, I can't think of any good scenario where it would be appropriate for the client to speak to the at-fault party insurance company. It is the lawyer that should be providing the information to the insurance company.